My name is Ashley Gurr and I'm a consultant solicitor here at LawBite. One of my key areas of practice is commercial law. In this video, I'll be discussing commercial agreements and the various aspects you should keep in mind when agreeing a new deal for your business. I'll be focusing on both the practical and the legal considerations. In other words, how to maximise your gain whilst minimising your risk. You will first need to come together with the other party to negotiate all the commercial elements of the deal. By this, I mean the basic nuts and bolts, including the nature of the goods or services being provided, the price, the timescales, the contract term, any exclusivity arrangements, and so on. Once the commercial terms are agreed in principle, you should put them down in writing. This document can then be turned into a formal draft agreement. This step is usually done by the lawyers. The draft agreement will flesh out the detail and will include various aspects the parties may not have considered when agreeing the commercial terms. Once the draft agreement is ready, it should be thoroughly reviewed by both parties and their lawyers to ensure that it mirrors the agreement reached, that the wording is fair and balanced, and that there are no hidden nasties, clauses that have been thrown in that may put you at an unreasonable risk. In practice, it usually takes a few back and forth amendments to get to a final version that both parties are happy with. We call the document that passes back and forth the travelling draft. If you use the Track Changes feature on Microsoft Word, then it's easier to see all the changes. Once you have arrived at a final version, it can then be signed by both parties and dated. You then have a legally binding agreement. The first thing you should do is to read the draft of the agreement very carefully, checking all the definitions and the detailed wording of the clauses. Is there anything that rings alarm bells? Has anything been included that you were not expecting? Has anything not been included that you were expecting? Take your time with this and be very thorough indeed. The next area to focus on are your contractual obligations. Are they fair and achievable, or are they too onerous? If you don't think you can meet the obligations, it is better to tackle it now rather than put yourself in breach of contract later down the line. One of the most important areas of risk management is to include a suitable limitation of liability clause. This is critical. If the worst happens and you do breach the agreement, the limitation of liability clause will cap your liability at a pre-agreed amount. Please note that care has to be taken with these clauses. To be enforceable, they have to be considered reasonable. Another area to focus on are indemnities. Indemnities are clauses that require you to pick up another party's liability in the event of a particular event occurring. These clauses can be very risky if they are not carefully worded, so you need to be on the lookout for them. This will all depend on how well the contract has been drafted and whether it actually reflects the commercial terms that have been agreed. The problems often occur when the written agreement does not properly reflect the actual deal. This is why the process of drafting, tweaking, and approving the document is so important. This all depends on what you have negotiated into the contract at the outset as regards termination rights. If you have a fixed term contract without any termination rights, then it may well be you are stuck with it for its full duration, even if you are losing money. For this reason, it's often sensible to include a termination on convenience clause in your favour. This enables you to get out of a loss-making contract by serving due notice. This is all about doing sufficient due diligence on your contracting party before signing the agreement. This is very important if you have never done business with them before, or if there are any warning signs such as previous solvency issues, etc. This due diligence could take the form of trade references, from other trusted businesses in your network or by doing suitable company checks before signing. Ultimately, a contract is only as good as the solvency of the company you are trying to enforce it against. Sometimes you may have to ask for extra security, such as a parent company guarantee, or limit your risk with strict credit control. As you can see, there are many areas that may catch you out. You may well need an expert legal eye to help you spot them. LawBite has experienced lawyers who are friendly and can help you with all commercial and corporate legal matters. We have successfully handled tens of thousands of inquiries from SMEs and are proud of our 98% positive feedback rating. I hope you have found this video informative. Thanks for watching.